right, this is cause number 21-10373, Exxon Mobil Corporation versus the United States of America. We're obviously ready to proceed. You may.
Great. Thank you, Judge Graves. Kannon Shanmugam of Paul Weiss for Appellant Exxon Mobil. May it please the Court, this case presents two important legal issues with enormous practical consequences for Exxon Mobil's corporate tax liability. The first and more practically significant issue concerns whether Exxon Mobil's transactions in Qatar and Malaysia should be treated as mineral leases, a term of art for tax purposes. The District Court erred by holding that they should. Exxon Mobil did more here than simply agree to extract oil and gas in return for royalties based on the value of the extracted minerals, as is the case in a conventional oil and gas transaction. Instead, Exxon Mobil effectively created new markets for natural gas in both countries.
Let me ask you, Counsel, first of all, if my understanding is correct, that every time gas comes out of the ground in these two fields, Malaysia and Qatar earn a royalty. They're getting money. They're getting paid any time gas comes out of the ground, right?
That is correct, based on the value of the finished product, which reflects considerable post-extraction activities. But we certainly don't dispute the basic proposition, Judge Costa, that Qatar and Petronas will receive more income if more oil and gas is produced. Okay,
so we're on the same page on that. So my question is, can you cite me a case where the transferor, in other words, the Malaysia, Qatar type entities, were going to get paid every single time oil or gas came out of the ground, and yet the court said they lost their economic interest in the mineral and effectuated a full sale to the other party?
We think that the closest cases are Anderson and Christie, but I would grant you...
There's a cap there, though.
Correct, which is to say that there are alternative sources of income there rather than additional sources of income.
But it's not just that there's other sources. I mean, in Anderson, I think it's $160,000 they were going to get paid. So if it was the biggest gusher in the world, didn't help the transferor. They were only going to get $160,000. In Christie, I think it was just over $5,000.
Correct. But my point was simply that, that amount could come either from the extraction of the minerals or from some other source, whether it's the sale of the land or the salvaged equipment in Christie. Now, I would note parenthetically...
But there are no cases where every time something came out of the ground, the transferor was still going to get money, because to me that means if you have a right to some of that money that's coming out of the ground, that would mean you still have an economic interest in it. But is there any case where if this is the biggest gusher in the world, they're going to benefit from that, and yet the court said you've really given up all your economic interest?
So we don't have a case that's directly on point. I will grant you that, Judge Costa. And so I think that the question that is before this court is how to apply the familiar test that has been articulated now for decades. And just to make sure that we're on the same page as to what that test is, that's a test that this court set out first in Christie, which goes all the way back to Anderson and the earlier Supreme Court cases, namely whether the taxpayer must look solely to the extraction of oil or gas for a return of his capital. Now, I want to explain first why we think that that is not the case here, and therefore the sale treatment is appropriate, and second, why I think that makes sense as a matter of broader principles. So as I indicated at the outset, here there are multiple additional sources of income. I think the sort of easiest one to understand is these facilities that were being constructed both in Qatar and Malaysia.
Let's say Exxon, instead of these oil, gas industry infrastructure, which was extensive in these agreements.
Yes.
I see all that. Let's say instead of that, as part of the agreement, Exxon said, we're going to pay you a royalty for everything we pull out of the ground, and we're going to build a Disney World-like amusement park in Qatar, and we'll split the proceeds. Sale or lease?
I think there would be a question there, potentially, Judge Costa, as to whether or not that's a single transaction. Now, there's no dispute about that here, and indeed, we presented undisputed evidence that the transaction could not be divided, and I think Judge Godbee effectively agreed with that, and I would point the court to footnote 14 at record page 5180 for that proposition. But I think our fundamental submission here is that obviously there's a very close nexus. We obtained the right to minerals in place, and in return, it was not sufficient for us simply to pay a royalty. We provided other things, and the facilities were, as you indicated in your question, enormous.
Let me, one last hypo, then I'm gonna let you do
Sure.
which one.
No.
Instead of the facilities, my understanding is in Qatar, those facilities are worth roughly $20 billion. If instead of that, Exxon just said, we're gonna pay you royalties on anything that comes out of the ground, and we're gonna give you $20 billion. If you wanna build do what you wish with it, sale or lease.
So I think in that circumstance where there's just sort of a flat payment, that might be viewed as analogous to the advance payments that were at issue in some of these other cases, really the cases on which my friend Mr. Carpenter primarily relies. And I think the way that the courts have conceived of those sort of lump sum payments is that they are essentially the equivalent of advance royalties. That's how they have been characterized in the line of cases like Palmer and Thomas. So I think, Judge Costa, the answer in that hypothetical is the same. But I think the reason why the facilities are sort of so easy to wrap up.
When you say the same, it's a lease.
Right, which is to say that the fact that there was a lump sum rather than a payment per, depending on the volume of extraction or net profits and the like, would have no legal significance. I think the reason why the facilities are significant is that, I think it really sort of sheds light on the fact that this transaction was really all about establishing and creating these new markets. It is as if Exxon agreed to, build the Beaumont or the Port Arthur refinery and to provide that at the end of the transaction. Now, to be sure, that is not the only additional source of income on which we are relying. We do point here to the abandonment cess payments, which, Judge Costa, I would note, I think probably somewhat distinctly from your hypothetical, don't depend in any way on extraction. Those are payments that would be made regardless of whether extraction takes place. And at least as to Petronas, I think we would say that those are an additional source of income. And then the third primary additional source of income, which I alluded to earlier, is the fact that here the payments were based on, depended on not just the extraction at the wellhead, but these significant post-extraction activities. And I think that's clearest with regard to Qatar, just because in the context of liquefied natural gas, you have these multiple steps that have to take place: transportation, processing, liquefaction itself, further transportation to the point of export through specialized vehicles, and so forth. And the evidence in the record indicated that those post-extraction activities added enormous value, somewhere in the neighborhood of 20 times the value in the case of Qatar, where the value of the natural gas at the wellhead was little to none. And so I think when you look at all of those...
Does it depend on the size of that additional profit that was added?
I think it would, only to the extent that if you had a case where there was de minimis additional value, perhaps a court would come out differently in those circumstances. But this is obviously not that case. Now, I will note that the government points to a variety of cases in which courts have said, well, the measure of value doesn't matter. And so if the measure of the value is, say, net profits, that's going to be okay. But I think conceptually the point that we're making today is very different, which is that here you're looking at all of this sort of subsequent post-extraction activity and the value that is added from that activity. And I would note parenthetically, we point to the dozens of administrative rulings in which the service has articulated the Soli test in the way that we articulate it here. One of the sources on which we rely is a technical advice memorandum that specifically involves liquefaction. And so I think that that is a ruling that is, if not on all fours, pretty darn close to what is going on here. Now, I do want to step back a little bit and talk about why this matters, and also talk about how our test differs from the government's test, because I think in some senses the court is deciding what to do in an area where so much of the law is obviously judge-made. It's not based on any particular statute or regulation. The first principles really do matter here. And I think there are really sort of two justifications for the Soli requirement as it has been articulated. The first is that mineral lease treatment is very much the exception rather than the rule. And we cite cases going back to, Eisner versus Macomber for the proposition that, ordinarily in tax law, exchanges of property in return for something of value are treated as realization events that result in immediately taxable income. And that's for the simple reason that where you have a transfer of property, you have a shifting of business risks, And so ordinarily the way you think about that is, all right, at that point, there is income to one of that parties, we're going to go ahead and tax that income. Mineral lease treatment really is a very specific exception. And it's an exception that I think has been narrowly construed because, ironically enough, that treatment is in many ways probably in the main more beneficial to taxpayers by virtue of depletion deductions and the benefits of depletion deductions being shared with the transferor in a case involving a depletion deduction. And it's no accident that when you go back and look at many of the cases on which we rely here, it's the government arguing for sale treatment and the taxpayer, often the transferor, arguing for mineral lease treatment. Now, to be sure, in this case, Exxon Mobil is here arguing to this court for sale treatment, and that is because it is beneficial to Exxon Mobil by virtue of the interest deductions it would receive here to have.
You're in the strange position of saying you want more income.
Yes, by virtue of the fact that we have enormous foreign tax liabilities, and we therefore have foreign tax credits we can apply against that income, but we also get the benefits of interest deductions. But I think when you look at sort of why the law has evolved in this way, the cases do sort of tend to construe mineral lease treatment very narrowly, again, because it is really an exception to the ordinary treatment of transfers of properties realization amounts. Now, there's one other policy consideration that comes into play, and I think it also comes into play when you're deciding between our proposed test and the government's proposed test, and that is workability. When you go back to Anderson itself, Anderson, when it first articulated this test, said that it was doing so, quote, in the interests of a workable rule. And I think that that workability is very important here.
Why isn't it workable just to say, look, as long as you're getting something out of each bit of gas pulled out of the ground, you have an economic interest? I mean, that seems very workable.
Well, except, Judge Costa, that I am not sure that that is really what the government is arguing for here. If you take a look at their brief, they focus on whether extraction and non-extraction income could be segregated into separate agreements. They seem to contemplate some sort of hypothetical analysis of that here. I don't think that that really has any footing in the case law, and indeed, if you look at the Supreme Court's decision in Southwest Exploration, it really seems to preclude that. But I think that that is not really something that would be very workable, and I think that the fundamental problem with a test that focuses simply on whether there is some economic benefit to the transferor from additional production, which is where we started, Judge Costa, in our colloquy, is both that that's inconsistent with the Soley test, as it is articulated, but also I would note that parenthetically it gives rise to exactly the same de minimis concern in reverse that the government suggests with our proposed test. And I think that that's why the government really focuses on this question of whether or not there could be segregation into separate agreements. I think it's really an effort to address that concern. And I would note that to the extent that that is a large focus of the government's argument here, that in the circumstance in which there was only de minimis additional income, and boy, let's look at this transaction and the billions of dollars of additional benefit to Qatar and Malaysia. This is as far away removed from that as it could be. But I think what I would say is that if a court were confronted with a situation in which the parties seem to structure their transaction in a manipulative way in order to take advantage of the rule, and we haven't seen a case like that, but if there were such a case, this is an area of judge-made law. The tax law is replete with de minimis exceptions, and I think courts would be equipped to deal with that. Now, I do want to say just a word about the second issue in the case, because I know I've only got a couple of minutes remaining unless the court has any further questions on the first issue. The second issue in the case is obviously the discrete issue of whether the alcohol fuel mixture credit alters the amount of a fuel blender's liability for fuel excise tax. Our view is that the better understanding is that the phrase in the statute credit against refers to a refundable credit that could be used to satisfy the tax. It does not reduce liability. Now, we certainly recognize that now two circuits have gone the other way in this issue. Most recently, the Sixth Circuit in the Delic decision, which is the subject of the parties' Rule 28J letters. But I want to say just a little bit more about that because that is, the latest word from a sister court on this issue. I think the fundamental flaw with the Sixth Circuit's decision is that it suggests that the phrase credit against, and in particular that the plain meaning of the word credit dictates the government's position here. And our fundamental response to that, and I think the reason why the Federal Circuit in its earlier decision set great store instead by legislative history, is because I think that the word credit is ambiguous and has to be defined by the context that surrounds it. If you look at the definitions of the word credit as something that takes away from or subtracts from a tax liability, I think that simply begs the question here. And I think that when you look at the context here, our submission is, first, that other parts of the tax code use the phrase credit against in a similar fashion. We obviously point to Section 31A1, which is the general withholding provision. There are many others. And that Congress elsewhere makes clear when it intends for a credit to work an alteration in the amount of the tax. And in particular, we point to the other provisions of the AJCA, where Congress made clear when it intended the deduction should be reduced by the amount of the credit or otherwise limited. And so I would submit that that is really where the Sixth Circuit went off the rails. And the last thing I would say, unless the court has any questions, is there's a lot of back and forth in the briefing about the alternative options to taking the excise tax credit. There's the ability to take a refundable income tax credit. There's the ability to take a cash payment. We think that the better view is that a taxpayer can opt for the cash payment without exhausting the amount of the credit, and that is because Section 6427E3 uses the word allowed rather than allowable. We don't think that that creates any inconsistency with the preceding section, Section 6426A1, because we think that to the extent that that provision also uses allowed in the phrase shall be allowed, that it presupposes the implicit condition that the taxpayer is in fact taking the credit. But regardless...
Your time has expired.
Okay, thank you very much.
Mr. Carpenter?
Good afternoon, Your Honors. My name is Clint Carpenter, and I represent the United States. Mineral leases are not an exception to sales. It can be a sale, it can be a mineral lease. I can walk into a car dealership and come out with a car. Maybe I bought it, maybe I leased it. They're both equal options. If anything, leases are the default because anything that isn't a sale for tax purposes is treated as a lease. So even things that might not be thought of as a lease in other circumstances are treated as leases if they're not sales. And for Exxon's transactions here to be treated as sales, Cotter and Petronas had to sever their interests in the oil and gas to be produced. And it's undisputed that they didn't. They retained interests in the oil and gas to be produced, interests that have paid them billions of dollars over the years. And because of that, that's an economic interest in the oil and gas in place, and that's all that is required for these transactions to be treated as leases. The Supreme Court said in the seminal Palmer case, quote, "It is enough if the transferor has retained a right to share in the oil produced." And that is absolutely what happened here. No court has ever held that transferor can't also negotiate for additional benefits in an agreement that aren't based on extraction and still have it be a lease. Those other benefits, they're just not relevant. The question is, did they retain an economic interest in the oil and gas? And it's undisputed that they did. Anderson and Christie are not to the contrary. They just established the principle that under this judicial doctrine, an interest in oil and gas that can be satisfied from another source as an alternative to being satisfied from the oil and gas, that's not treated as an economic interest. But that's not what we have here.
But in Christie, there was this salvage value, but that probably wasn't going to cover the whole contract price. They were going to have to look to the oil to get paid.
Well, potentially. It was a small amount. But the way the contract was structured, that whatever they took, if anything, in salvage value would reduce the amount of the payment they got from the oil and gas. So if the oil and gas payment was the total amount they were entitled to is $5,000, and they got $2,000 of salvage value, then they would only get $3,000 from the oil. That was how the contract was set up. And so the salvage was an alternative to the oil payment. I'm not sure if the salvage could have covered the entire amount or not. But like in Anderson, it was an alternative source from which the payments could come. In other words, the transferors did not have any right to payments that could only come from oil and gas. That isn't what we have here. What we have here is what we have in all of the other cases that were found to be leases. We have Costa and Petronas both have rights to payments that can only be satisfied from oil and gas. They also have rights to facilities and these other things, but that's separate. That's an addition.
I mean, is the only thing being disputed for tax purposes here in this case is the income from the gas extraction?
Well, yeah, this case is unusual, as you mentioned earlier, and it really even.
What do you do with the fact that there's all this added value that he's talking about?
Right, and this case doesn't even really deal with the income. I mean, Exxon has this theory that we've disputed, and that the district court didn't need to reach. But they have this theory that if it's treated as a sale, then they're under section 463 of the tax code, then they can treat part of their payments to Costa and Petronas as interest, and then some of that is foreign source, and then they can use these foreign tax credits. So it's not even really an income issue or a depletion issue, which is what most of the cases deal with. The parties we don't disagree that the test for whether it's a sale or a lease is still the same, but that circumstance is different. This is kind of an unusual case, and yeah, you're right in the sense that it is odd. They're sort of asking for to increase their income because they believe that it will have this follow-on effect with foreign tax credits. Let's see. In terms of the valuation, this court held in Wood that it doesn't matter how the payments are valued. The payment, whether the payments are based on a market sale price, whether they're based on net profits, whether they're based on the value of the oil or gas as it comes out of the ground. All of those, they're all derived from extraction of the oil and gas, and that's what matters. That some value is added to the oil and gas itself to make it marketable or saleable. That doesn't mean that the payments aren't still derived from extraction of the oil and gas. If you don't extract the oil and gas, you can't do these other things to sell it. And so,
what about his argument that your view would allow sort of a de minimis possibility of oil and gas extraction to change the nature of an overall agreement that has mostly other components? Sure,
that's fair. I mean, that's true. It goes both ways. So you can have on the one hand that they add, they have a de minimis. We'll give you $1 for however many barrels of, 8 billion barrels of oil. We'll give you $1, and now it's a lease. On the other hand, as you're saying, yes, from our perspective, there could be this de minimis. It could be on the other side where we'll pay you a percentage for the oil, plus we're going to buy the facilities for $5 or something like that. And so none of the case law speaks to a de minimis situation going either way, and perhaps that might be a case where kind of that predominant purpose issue that the district court brought up might come into play. There could be a number of ways to address it. Our position is not that a de minimis amount should change the calculus either way. And so if a case were to come up where that were to happen, we aren't suggesting that a de minimis amount would resolve the issue, but that's just not what we have here. We have substantial amounts of deferred payments, royalties, and we also have substantial amounts of the other types of compensation, like the facilities. One thing I'll just mention quickly about the facilities, this didn't really come up in the briefing, but in terms of the facilities, Cotter actually already is a part owner of the facilities because Exxon partnered with these Qatari entities, and so Cotter is on both sides of the transaction. They're both the transferors, but they're also, through these entities, they're partners with Exxon as transferees of the oil rights. And so they'll be, when the leases expire, these facilities that they already partly own those facilities through those entities. In terms of the workability, Judge Costa, as you said earlier, the government's test, which is the test that the courts have always applied, is just as workable as this new test that Exxon is proposing. It's simple. It is if the transferor has retained an economic interest, then it's treated as a lease. And it doesn't matter, all of these other things. The workability issue that the Supreme Court was concerned about in Anderson was that if you have an interest that could come from the oil, could be paid from the oil, or it could be paid from a sale of the land or salvage value. If you have an interest that could be paid from either one, then you would have to wait until after the fact and see how it actually got paid out before you would be able to decide if it was a sale or a lease. That was the workability issue that Anderson was concerned about, and so they resolved that by just deciding up front that in that situation, we're not going to count that as an economic interest. We don't have that situation here. There isn't that workability problem. So I think it's important to note that Exxon's position has been rejected by this court at least twice. In the Gray case, the same argument was made that the existence of other rights in addition to the royalties defeated an economic interest under Anderson, and this court rejected that. The court said it was patent that the rights to royalties plus these other additional rights represented an economic interest in the oil and gas. There wasn't really anything to even argue about, and the court said that Anderson was distinguishable on that basis, specifically because in Anderson there wasn't a right to royalties that, there wasn't a right to payments that could be derived only from oil and gas. In Gray there was. The Weinert case also, the court rejected the same argument. It described the position that Exxon is advancing as unreasonable. It's just unreasonable to argue that merely because a party had rights to income from a processing plant, in addition to its mineral production rights, that the entire character of the leasehold rights as an economic interest is destroyed. That argument, they said, was unreasonable. They said if the taxpayer in that case had no economic interest in the production, no one had. And so Exxon is advancing a position that this court has rejected at least twice. It's based on what they're calling a rule that is not a rule that the courts have ever applied. If the language that they're relying on in Christie meant what they say it does, then we've got a dozen Supreme Court and Fifth Circuit cases that were wrongly decided. So you've got Gray and Weinert, where there were processing facilities, rights to processing facilities in addition to royalties, extraction-based royalties. You've got several cases that we cited in our brief involving guaranteed minimum payments regardless of extraction. Those would all be wrongly decided if the rule were what Exxon says it is. And then also the cases with the upfront cash. Whether that upfront cash is treated as royalties for tax purposes, it is a factual matter. They weren't royalties. They were because they were not based on extraction of oil and gas. The amounts that the parties got in those cases, the upfront payments, they received those regardless of whether any oil or gas was extracted. And so under Exxon's theory, those upfront payments should defeat an economic interest, but in Palmer, Thomas, Kirby, Albritton, all of those cases, the courts held that they had an economic interest despite the upfront payments. Albritton, Wood, and Rutledge despite guaranteed minimums, and Gray and Weinert despite processing facilities. And that brings us to our cross appeal, which is on the penalty issue. Not only is Exxon's position wrong, but they are liable for the penalty because it doesn't even have a reasonable basis. Again, they're relying on, they're taking some language out of Christie that comes from the Southwest Exploration case, and reading that language in isolation, and they're reading it in a way that would make all of those other cases wrongly decided. That's not a reasonable reading, and that's not a reasonable basis. In the Chemtech case that we cited in our brief, this court held that the case law, the cases that conflict with binding on-point authority don't establish a reasonable basis for a tax position, and so therefore don't satisfy the defense to the penalty.
Let's say someone has an ice cream shop and they're tired of running it, and they tell someone else, you come in, you take over the shop, you can get all the profits, but you give me 50 cents of every ice cream cone you sell. How is that treated for tax purposes?
Wow, so you're asking me like I'm a tax lawyer, and I'm more of a litigator. How is that treated for tax purposes?
Or is that a sale or is that a lease?
If we pretended that ice cream is a mineral, then I would say that's treated as a lease.
Are there special rules for minerals? I guess
my understanding is that the rules are different for minerals. Yes.
Does that get into their point that it's the default should be it's a sale?
No, I don't think so. I think it depends on the transaction. If I bought the ice cream shop and that's it, here's $1 million, here I get the ice cream shop, then that's a sale. If here's $1 million and I'll give you 50 cents of every scoop that I put out, that's a lease. And in fact, yeah, I mean, that would be exactly the situation in the Palmer case that sort of started this line of.
So it's the retention of an economic interest.
Yeah, in that situation, you in selling me the shop, well, in transferring me the shop.
You would say that the person who used to run it still has an economic
interest. Yeah, exactly. The person
who
used to
run it. They get 50 cents every cone.
That's right. They've retained an economic interest in the cone. And so, in ice cream context, I'm not sure if that has the same tax effect. But in the oil and gas mineral context, that's treated as a lease.
There are a lot of ice cream cases that are getting litigated for
it's a shame.
$1.5 million.
I like ice cream more than I like oil and gas, but I have not come across an ice cream case. So, let's see. Let me speak briefly about the mixture credit case. I think the Sixth Circuit's decision in Delic just about a month ago, as well as the Federal Circuit's decision in Sunoco, those decisions are right. We think that Your Honor should follow those decisions in this case. They confirm the common sense principle that a taxpayer can't deduct quote unquote costs that they didn't actually pay. That's what Exxon's asking to do here. They got a $960 million excise tax benefit from claiming alternative fuel mixture credits against their excise tax liability. But now they want to also have the income tax benefit of pretending that they paid that excise tax instead of getting the credit. That's not how it works. Congress could set up a system where you could do that. But that's certainly not the way it ordinarily works, and that's not how this system works. Like the Sixth Circuit found in Delic, a credit reduces the credit reduces excise tax liability because a credit means, quote, an amount subtracted from one's total tax liability, dollar for dollar, as opposed to a deduction from gross income. It's a subtraction. It's not a payment. Exxon kind of walks this fine line and tries to say, well, it satisfies the excise tax, but satisfying it wouldn't be enough. If you want to treat it as a cost for income tax purposes, you have to have paid it, and they didn't pay it, and the tax credit doesn't pay it. It reduces your excise tax liability, and if you reduce your excise tax liability to zero and you still have mixture credits left over, then you can receive those as a payment, like a refundable income tax credit.
If they had paid full $6 billion, if they had paid that, then could they have requested a $300 million refund?
Yeah, well, Yes, they could. I mean, they would need the refund because they would have claimed it on their returns originally. But yes, that's right. So if they had said, we're just going to forego this excise tax credit, then absolutely, they would have paid the excise tax out of pocket, and so that would have been a cost that they could then deduct on their income tax from their gross income. But that's not what they did. So even if there was a choice between choosing the mixture credit and a cash payment, as they're talking about, Exxon made its choice and they chose the credit, and it was $960 million to them, and so they're not entitled to also get the income tax benefit as well. Mr. Shanmugam mentioned, analogizing to Section 31 in terms of what credit means. The court in Delic addressed that. I would just refer to your honors. We think the court got that right. It's in, I even have it here. It's page 501 it's 32 F4th at page 501 where the court addresses that. And it takes the position we argued in our brief, and we think that's right. All right, I see that I'm almost out of time. If there's any other questions? All right, thank you. We'll rest on our briefs as to any other issues.
Thank you, counsel. Rebuttal.
Thank you, Judge Graves. On the first issue, there can be no doubt that the way that the test for sale or mineral lease treatment has been articulated by this court, by the Supreme Court, and by the service in dozens of rulings is whether the transferor is entitled to income derived solely from the extraction of the minerals in place. And I think in an effort to tweak that test, what the government has done here is essentially to sort of jerry-rig a test that is articulated differently so as to cover this case. The way that the government puts it in its brief is that the test is instead whether a transferor has a, quote, right to compensation that looks solely to extraction. And as a practical matter, what that means is that if the transferor receives any income that is dependent on extraction, a transaction should be classified as a mineral lease. Now, the key cases here, in our view, are Anderson and Christie. And as I think became clear in the colloquy between my friend and Judge Costa, the problem here for the government is that in both Anderson and Christie, it was clear that the payments could constitute a mix of mineral and other income. In the case of Anderson, the payments could come from any or all of the land conveyed. In Christie, it could come from the salvage value of any or all equipment. And as Judge Costa indicated, there's nothing in the court's opinion in Christie in particular to indicate that the salvage value of the equipment could satisfy the entire production payment obligation. And as to the other cases on which the government relies, Palmer and Wood are clearly distinguishable because they're not cases that involve additional sources of income. And I think that the government is really left with this court's very cryptic decision in Gray. Now, to be sure, in Gray, which did not contain a great deal of elaboration, the royalty interest in question was accompanied by another interest, a contingent interest in a processing plant that was dependent on extraction. Here, there are sources of income that are unquestionably not dependent on extraction. But again, given the absence of any elaboration by this court about the nature of that additional interest, I think that that's a very thin reed on which the government relies. And I think Weinert, if anything, helps us because that's a case where this court distinguished between income from activities that were indispensable to extraction on the one hand and income from other activities such as fractionation.
Counsel, you mentioned in your opening, you said this is an area where we should look at first principles because there's no big statutory scheme, it's judge-made law. And first economic principles, to me, I'll go back to I think where I started, if I'm getting paid every time gas comes out of the ground, how can that not mean that I have an economic interest in every bit of the gas that comes out of the ground?
I think what I would say to you, Judge Costa, is that is really where the solely comes in, and the solely comes in, I think, because of these concerns about workability. So could one posit an economic interest test like the one that you've just suggested? Yes, but I think that the test as articulated by the Supreme Court and as applied by this court, when it's talking about the transferor bearing the risk of non-production, I think what that really means is this a circumstance in which the transferor will realize no income unless minerals are extracted? I think that that's really what the risk of non-production in this context means. And I think that, again, I think what's really going on in this case is that the government is attempting to modify this well-established test for the simple reason that it lacks the jurisdiction to tax Exxon Mobil's counterparties here because they are foreign sovereigns. And so our fundamental submission is that there's no compelling reason to deviate from that test. And on the second issue, I think that the one thing that I would say is that the anomaly that is created by the government's test is that it would essentially eliminate the dollar-for-dollar benefit from the fuel tax credit where a taxpayer takes it as a credit rather than as either of the other two options, a cash payment or an income tax credit. And that is for the simple reason that under the government's approach, a taxpayer like Exxon would get only 65 cents or so on the dollar because their corresponding deduction for the cost of goods sold would be reduced. And there's no good reason that when Congress provided the optionality as between these various ways of taking this benefit, that it intended to disfavor an excise tax credit. There would be no windfall to the taxpayer in that circumstance. The taxpayer would simply be left worse off. And so we would submit that the judgment of the district court should be reversed on either or both grounds.
All right. Thank you, Mr. Shanmugam. Mr. Carpenter, the court will take this matter under advisement